Hi, good morning or good afternoon. I'm Jonathan Pompan, partner at Venable here in Washington, D.C., joined by my colleagues throughout the country, including in New York, in our D.C. office, to discuss an update on consumer financial services investigations and enforcement. Now, before we get started, a little bit of housekeeping. Now, today's session is going to be recorded and it'll be available for CLE. In addition, a legal disclaimer. This session is not legal advice. It's just for educational purposes only. Now, for CLE, for live participants, there will be a certificate that's sent later this week, as well as a download for the recording and also for the slides. That'll be sent later this week to all registrants that attended the live session. For those attending after the live session, we thank you for joining us today. Now, at the CFPB, there's been no shortage of activity over the last 10 years, but today's session is going to focus on financial services enforcement and investigations. We're going to provide an update on regulatory investigations and enforcement priorities across the agencies, and then focus on fair lending because it's back. The new focus on complex investigations and prosecutions of criminal misuses of cryptocurrency and virtual currency, the CFPB's interest in data harvesting and payment systems, and how the CFPB is going big and what that means, what sectors might be next. They've already targeted big tech payment systems, are others in the queue. And we're going to provide insights today about defending an investigation, observations from the front lines in preparing for litigation. Not all investigations are the same, and some investigations are extremely complex, multi-year. Some investigations may end even with a closing letter. Our attorneys with experience in investigations and enforcement across the agencies have been on the front lines and have seen and participated and defended organizations in all types and sizes. I'm joined today by my partners, and we'll introduce each one now. Andy Arculin. Andy?
Sure. Thanks, Jonathan, and welcome everyone. So my name's Andy Arculin. I'm chair of the Financial Services Group at Venable and also a CFPB alumnus. I was in the CFPB Office of Regulations from 2012 to 2015. And my practice at Venable focuses heavily around consumer lending, fintech, and mortgage banking. Andrew Biggert, you're next.
Great. Yeah. Good afternoon, everyone. Andrew Biggert, also out of the DC office. My work is mostly focused on representing payments companies and other fintech companies in terms of their regulatory compliance and transactional needs. And Michael, I think you're next.
Hey, everybody. I'm Mike Breznick. I work in the DC office of Venable. I spent 10 years at the Department of Justice prior to coming to Venable, handling a variety of financial fraud matters and investigations. So at Venable, I represent financial services companies handling investigations from a wide variety of government agencies such as DOJ, CFPB, FTC, SEC, and state AGs. Alan, you're up.
Good afternoon, everybody. I'm Alan Denson. I'm also in the DC office of Venable, and I help people who are navigating investigations, exams, and regulatory inquiries from primarily the CFPB, but also the Federal Trade Commission, state attorneys general, and other financial regulators. And let me turn it over to Len.
Good afternoon, everybody. I'm Len Gordon. I lead the advertising practice at Venable. I joined Venable several years ago after leading the Northeast Regional Office at the FTC. At Venable, I spend most of my time defending FTC investigations and litigation. Also do a lot of work with the CFPB, State Attorneys General, and the United States Department of Justice. And let me turn it over to Alexandra.
Good morning or good afternoon. I'm Alex, also in New York. A Venable lifer where I've represented companies before the FTC, CFPB, and state AGs, and with a particular focus on the debt collection space, both from a supervision and enforcement perspective. And Jonathan, back to you.
Thanks, Alex. And again, I'm Jonathan Pompan, partner and co-chair of our Consumer Financial Services Group here at Venable. and have been in the trenches opposite financial services regulators for over 16 years now, including the CFPB for the last 10. That practice leverages the knowledge of fintech and the consumer financial services laws with respect to product development, compliance, and of course, investigations and enforcement. Now, before we get into the hot topics of today, it's important to take stock of where the Bureau has been. Now, over 10 years old, the CFPB has ordered over $12.9 billion in consumer relief through a combination of litigation and enforcement settlements. Over 175 million people have been eligible for that relief and over 1.6 billion in penalties. Now, that's through 2020, and roughly since the beginning of the CFPB to today, there's been about 302 enforcement actions, some of which have been settled and some of which have been litigated or are presently being litigated. 17 just this past year were announced, and of course, there's several hundred more investigations that would have been launched as a result of that. And of course, CFPB examinations under the supervisory authority feeding into the enforcement and investigations area of the CFPB. Alan, we were talking earlier about the nature of the CFPB's history. What's your take on how active it's been? I know there's some misnomers that it hadn't been active in recent years and therefore that there's nothing in the pipeline, but I think nothing could be further from the truth.
I think that's right, Jonathan. And what we were talking about is that the actual number of investigations and enforcement actions has ticked up substantially over the last year. And while the relief number is not quite as high as we saw in 2015 and 2016 when we had very large penalties like the Wells Fargo case, the actual number of investigations has really crept up. And the other kind of major trend that's not shown in the chart here is that we've seen a major trend at the CFPB towards naming individuals. In fact, in this year, even though this is largely a discretionary thing that the enforcement staff is able to push, but we've seen roughly half of CFPB actions name some type of executive or individual. And I think the idea here is that naming an individual is viewed as more of a deterrent from the enforcement staff and CFPB leadership. So the numbers that we see now in terms of new investigations will be larger penalties, I think, in the next few years.
Indeed. And, the cumulative history of the CFPB, there's been enforcement actions that have intentionally touched all corners of consumer financial services, whether it be banks, large banks or non-banks, fintech, student lenders and servicers, mortgage, debt collectors and debt buyers, and service providers, including payment processors and lead generators. But now turning to the enforcement priorities that have been identified already with the new CFPB, Rohit Chopra was sworn in just a little bit more than a month ago and has already been extremely active at the Bureau. In fact, he's testified before Congress, and he's also been a part of some large-scale public announcements about jointly with other government agencies. But his history doesn't just start just last month, as most people are very familiar with already. He had been a commissioner at the Federal Trade Commission for a number of years, and then previously served as the student loan ombudsman at the CFPB, and in fact, actually had gone to Harvard at the same time that Elizabeth Warren was a law school professor there. Now, Rohit's not a lawyer, but he is extremely active in using the law and adept at using the law to accomplish the goals that he's setting out from a consumer protection standpoint. Len, let's start with you. Len, you were in the trenches at the Federal Trade Commission during the Obama administration, in particular, running the New York regional office when David Vladeck was the head of consumer protection at the CFPB. He's a Raider Nader, held prominent positions at Public Citizen, heading up the litigation group, and believed very much that government and the agency that he was running at the time in terms of the Bureau of Consumer Protection should use the law to move the needle, to help companies conform to what the expectations are of what the law should be, not necessarily what Congress maybe had written. Do you see parallels here with Chopra, and particularly because he's essentially has no limitations on his authority as compared to, say, the FTC?
It's an interesting question, Jonathan. In some ways, they're both very aggressive consumer protection enforcers, both willing to push the law, but I think their background reveals some really important differences. David Vladeck was an exquisitely talented litigator. He's one of the more talented lawyers, trial lawyers I think I've ever encountered. I think most people who encounter him would say that. He's argued cases before the Supreme Court, and he has a personality that just absolutely dominates a room, and he used that personality to get what he wanted, whether it was from the commissioners, from adversaries, from staff, but in a nice way. Commissioner Chopra is just not as charming. I don't know how else to put it. And he I don't think will have the same loyalty with the staff that Vladeck had. He also doesn't have the wisdom, I think, that David would have had from litigation. David had very ambitious goals, but he also was willing to make judgments to settle cases or to not pursue cases because of his litigation sense that I don't think Sheriff Chopra has. And I think that showed at the FTC. He was very hard on staff and frequently was willing to dissent. When David Vladeck led the Bureau of Consumer Protection, he worked for John Leibowitz, who was the chair, who was very much always trying to drive to consensus and was willing to compromise. And I think some of that lack of willingness to compromise was shown in many of the dissents that Chopra issued. So now that he's running the CFPB, and he doesn't have to worry about dissents, he's still going to need to build consensus with other financial regulators, with his staff, and whether he can do that, I think we'll have to wait and see.
And Andy, as somebody who had been in the trenches at the CFPB during the Cordray administration, what's your take on the direction of enforcement, the climate at the Bureau today?
That's a good question. So, a lot of, you hear a lot of people saying it's, a return to the Cordray era. It's basically a reset, after the Craninger administration and so on. I think that's partially right, but partially not. If you think about Rich and who Rich was, he also was a prosecutor and a politician, right? And when he was in charge of the Bureau, when I was there, the enforcement directive, a lot of it really came out of the financial crisis. And they were really older legacy issues. You have things like payday lending, mortgage servicing practices, mortgage origination practices, and debt collection practices, and so on. Rich was certainly ambitious. I think was himself not afraid to push the envelope through enforcement. I think the term regulation through enforcement started when he was in charge. And then that, obviously got scaled back quite a bit under Mulvaney and Craninger. Rohit's going to be similar, but he is different. He's not a lawyer. He's not a prosecutor, as you said, Jonathan. He is very much an ideas person. If you're drawing a political comparison, I would say it's almost like comparing Cordray to Rohit is like comparing Biden to Elizabeth Warren, right? You have more of an old school liberal first. Now you have someone who's way more progressive. Rohit has a lot of big ideas. You've seen that there's been a lot of chatter and buzz about subpoenas going out to big tech companies that it's not really clear what the CFPB intends to do with them. They look at this point like a fishing expedition. They're not enforcement subpoenas, they're not CIDs, but they're in many ways styled like them. And lots of this information collection that the Bureau is using other authorities to basically build a record and decide how it wants to regulate some of these industries. You also will see, and this is again part of the political mandate from the election last year. Fair lending is back with a vengeance. There's a lot of belief within Bureau staff that fair lending was put to the side and ignored for the last 4 years. There's a lot to do there. We're going to spend some time talking about it. That is absolutely going to be an enforcement priority, and we're already seeing it. They're also getting into some areas where the Bureau has not been as active as other regulators. Like, you hear this term fintech. A lot of those relationships are non-banks partnering with banks that the CFPB technically doesn't supervise or have authority over. They are more interested in going after the non-banks. They're more interested in going after lending arrangements. And I'll let Alan add some flavor as well. And one thing we've also been seeing, keeping with this theme of payback for the Craninger administration, is there were a lot of settlements, consent orders that were entered during the Craninger administration that I think CFPB staff was a little disappointed in. They thought didn't go far enough. The Bureau settled too favorably. And the Bureau has been saber rattling, sending information requests to parties who are under consent orders, basically browbeating them for noncompliance. And in some cases have even gone and filed lawsuits. There's been several already for noncompliance with the consent order. So that's something else that's relatively new. And Alan, anything you'd add there?
Yeah, just as someone who deals with these folks every day, I would say the single largest area where I've seen them kind of probe is on people who have signed consent orders in the past. And they're going back and revisiting, they're checking on compliance, both through examinations and through CIDs. And it's a really big priority for them now.
Yeah. And also was, there is a new enforcement director, Eric Halperin. Mike, I know you know Eric, so I wanted to give you a chance to speak to his, his habits of the mind, so to speak.
Yeah. So, I was listening to the way Len described Director Chopra, and I don't know Director Chopra at all. I've heard he's very smart, and I think we all can expect that he's going to be aggressive. But I do know the guy he hired for his enforcement director, Eric Halpert. I know him pretty well. We worked closely together at the Department of Justice when I was there. And I was executive director of President Obama's Financial Fraud Enforcement Task Force. And Eric was a leader of the non-discrimination group. The co-chair of that group was Tom Perez, who was the head of the Civil Rights Division at DOJ. But really, the day-to-day guy, the guy that was doing most of the work in that from DOJ side was Eric. And as executive director of the task force, I would work closely with Eric and move forward the mission of that non-discrimination working group, which focused on fair lending. And Eric is nothing like the way that Len described Director Chopra. If I suppose it's possible that somebody could be one way, but it also says a lot about the guy, that he picked Eric. Eric is, he's collaborative, he's cooperative, aggressive to be sure. I mean, he's going to work hard to advance the mission of the Bureau. And I think especially we can expect fair lending matters. But I think he's going to have strong support from the members of his enforcement team. I think outside counsel that deal with the enforcement division and have an opportunity to present to Eric and meet with him, they're going to find that he's receptive. Might not agree with everything you say, but I think we wouldn't expect him to. But he is eminently reasonable and well liked and respected.
Mike, if I could put you on the spot for a question, I noticed that Eric has a stint in the Center for Responsible Lending. And I wondered if you had any thoughts on how that informs his view as an enforcement director.
Yeah, I mean, well, Eric he's a career public servant. I mean, I can't say I know everything on his bio, but I don't know that he spent any time in a law firm. I mean, I think he spent all of his time either at DOJ doing civil rights work or nonprofit organizations such as CRL or Open Society Foundations or Civil Rights Corps. He's a true believer for sure. I think he certainly has maintained strong connections and friendships with people, among consumer advocates. I think if you talk to any leading consumer advocate, certainly in the DC area, and I'd venture to say throughout the country, they'd know who Eric is and think well of him.
Well, that speaks to the pushing of the envelope theme that has already emerged with what the CFPB enforcement priorities are. Now, that being said, they're not the only sheriff in town. The Federal Trade Commission has been extremely active as well. Certainly, they share enforcement authority over a number of consumer federal financial laws with respect to financial practices. And then there's a number of other general statutes for which they enforce, including obviously the Section 5 of the Federal Trade Commission Act that gives them broad authority to both push the envelope on unfair and deceptive, but then also perhaps whisper in the ear of the CFPB. Now, Alex, one of the things that struck me in a recent statement that Chair Lena Khan, new chair, had published to staff at the Federal Trade Commission was this interest in private equity, private investment, and the nature of how that can impact consumer protection and also the competitive nature of the marketplace. Any take on what also is going on at the Federal Trade Commission?
Thanks, Jonathan. Well, I mean, I'll certainly let Len weigh in on some, broader issues with respect to Chairwoman Khan's vision and agenda at the FTC, in particular with respect to financial services, which the FTC still has jurisdiction over, sans, banks. But the statement that you are referring to with respect to private equity, I think, goes to a theme of kind of not just looking at the direct actors that are making the specific statements, representations, selling the goods to consumers, but also those that are behind the scenes that are, financing and otherwise facilitating or helping or benefiting from those practices. And I think she plans to take that type of approach in her enforcement strategy. And so those types of companies, and this is not new. I mean, we've certainly seen in prior administrations and payment processors, for example, have been dealing with this for at least almost a decade now, where these kind of choke points or companies that benefit behind the scenes, the tolerance for them kind of turning a blind eye is going to be extremely reduced under this FTC. And I'll let Len jump in on other FTC initiatives that are impacting today's audience.
Thanks, Alex. I mean, one of the things I think you're going to see is an unprecedented level of coordination between the FTC and the CFPB. Lena Khan worked for Chopra when he was a commissioner. She was one of his advisors. They've published articles together. They take very similar views of the big tech platforms. They're both very hostile. Lena Khan sort of made her academic bones writing articles about Amazon. So, I think the two agencies will coordinate, and that those two will be talking daily. Negative option marketing has been a target of the FTC's for years, but I think that's going to ramp up even more, and especially for financial products that are sold on a subscription basis. You'll see more enforcement there. The FTC recently updated the safeguards rule, as well as putting out additional proposed rules in that area. Interestingly, there was some dissent by the two Republican commissioners over the fact that the rule was overly prescriptive and was sort of moving away from the type of flexible approach that the FTC had garnered before. And perhaps emblematic of the cooperation between the two agencies, that rule was published after Commissioner Chopra had already taken his seat at the CFPB, but he still managed to vote for it with a zombie vote, as they're calling it. So I think that's emblematic of the amount of cooperation you're going to see between the two. And then finally, the big tech platforms are clearly in both agencies' crosshairs, and there's going to be a confluence between antitrust issues and consumer protection issues, and I think there'll be cross-pollination between the two bureaus, and a lot of activity where it's not clear which bureau or both are targeting conduct.
And Alan, another area that we've seen cooperation really throughout the last 10 years, but really in particular, even just the last couple months, has been between the Consumer Financial Protection Bureau, CFPB, and states' attorneys general, which actually are just wrapping up this afternoon their annual Consumer Protection Conference here in DC, where they've been powwowing to coordinate on their own activity and get briefings on various things, including financial services. What are you hearing or sensing from the work that we're all doing with respect to state attorneys general?
Yeah, we can't forget about the states, and each of these priorities listed here could also be priorities of the CFPB and Federal Trade Commission. And we see a lot of coordination between the state and federal level, and between the states themselves as they look to investigate wholesale industries. And a special call out should go out to the California Department of Financial Innovation and Protection and the New York DFS, which have both been extraordinarily active in 2021 so far. And we'll expect to see more from them as we head into next year.
Now, switching gears, fair lending is back. The Department of Justice, the CFPB, and the banking agencies have been signaling for the last several weeks an increase in fair lending enforcement. Certainly, we've been talking and sounding the alarm about fair lending compliance for the last year, sensing that this was going to take place. Now, Andy, typically when we think of redlining, we think of mortgage, but it turns out it's broader than that. Briefly, for a thumbnail for our audience, how should everyone be thinking about redlining, fair lending, and just generally the variety of different ways it can impact financial services, not just mortgage?
Sure. So, I guess just at the outset, I would say part of the Biden administration's political mandate that was handed down to Chopra is to, basically get back on fair lending. I think there's a lot of views within the Bureau, with other agencies, and just in general that fair lending was not actively enforced, for the last several years. It was deprioritized. The Office of Fair Lending at the CFPB was basically taken out of the Office of Supervision and Enforcement and put under the director and so on. And there's, a lot of life has been breathed back into their fair lending operation, but it goes beyond the CFPB. And, I want to make sure Mike jumps in here as well, because he's a DOJ alum, but there is basically a broad mandate across the different enforcement agencies to learn more about, potential discriminatory patterns in this digital age, which I think is really ultimately what makes it different, and to launch investigations and to enforce against bad actors. And then to Jonathan's point about compliance, there also are institutions who are routinely examined by the OCC, the CFPB, whomever. One of the underlying themes is redlining. I think has traditionally been thought about as banks or other depositories positioning their offices around minority concentrated neighborhoods, not making efforts to lend into minority concentrated census tracts or neighborhoods and so on. And that's a bit of a thing of the past. It still comes up. This case that we're going to talk about in a minute, American Trustmark, still very much involved those elements, and the bank regulators still examine for Community Reinvestment Act and so on. But what we've started to see, and it really goes back a couple of years, is focus on the marketing component of credit lending, decisioning, and so on. Not necessarily just outcomes and pricing, but where you market, how you target your audience, and so on. One of the words you see in these various actions is exclusion. If there's anything that signals exclusion in your marketing practices, where you're focusing on one group to the exclusion of another, that is now being viewed, and it's rather creative, as a form of redlining, a form of discrimination, and in credit practices. There have been several cases, investigations already. One of them that's not mentioned here is the Townstone financial case. The CFPB actually brought that during the Craninger years. And that was, again, it was a non-bank mortgage company that was, according to the allegations, excluding parts of the Chicago MSA that were minority concentrated, even to the effect of having a radio show that the CFPB viewed as derogatory. So the CFPB has been enforcing in areas like that. There also is this American Trustmark case, right, which is a traditional redlining case. It really is about a bank and where it's located and how it markets its loans directly. But some of Chopra's statements really have talked about AI and algorithms and these things that aren't necessarily front and center in that case itself, but signal the Bureau's priority in looking into fair lending. And Mike, I know the DOJ has a heavy hand in this too. So anything you would add?
Yeah, I mean, I think the common theme of this webinar is coordination. I mean, that's Len was talking about it with FTC and CFPB, and Alan's talking about it. I mean, and everybody, that's what this is all about. The redlining initiative was announced by DOJ in conjunction with this Trustmark National Bank resolution, and it's further coordination between the Department of Justice, being led by the Civil Rights Division's Housing and Civil Enforcement Section, to work with U.S. attorneys' offices around the country to further coordinate with CFPB, OCC, Federal Reserve, to give a focus to FHA and ECOA issues, such as redlining, for one. I mean, this is really a blast from the past, back to the days of the Financial Fraud Enforcement Task Force. This is exactly the work that the Non-Discrimination Working Group was doing. We were involved. We did redlining cases in. We did the steering case with Wells Fargo, where they were steering African-American and Hispanic borrowers to higher price loans and to subprime loans. So it looks like what's going on now is, rather than one large task force, the kind that I was overseeing, the Financial Fraud Enforcement Task Force, we have little mini task forces. So we've got a redlining task force here. We're going to talk a little bit about the cryptocurrency task force over there. Whether it's under one umbrella or little mini task forces, the point is the same, which is that government is working together. They're coordinating, as they should be. That's what good government really ought to do. But what it's signaling to us, the public, and to our viewers in the webinar, is that this is an important matter for these various government agencies. They're focusing on it. They're going to be coordinating, sharing data, prioritizing issues. And I think we can all expect to see a lot more enforcement in these areas, as we've all been saying.
Yeah, Mike, I mean, good point. And to Andy's point as well, it's almost as if the government's creating a national bureau of advertising for lending, not just focused on the lending products themselves, but how they're marketed, how they're advertised, to right down to where the brick and mortar storefront might be, or what the website design, or what the pictures are going to be used in a particular advertisement, seem to feed into the theories that the Bureau and others are using in enforcement. Now, Alan, switching gears a little bit, but also on the fair lending note, Director Chopra has been very critical and highlighting that the use of AI and machine learning falls under the scope of fair lending. And it is a tool that can be used for good. It can also be used, apparently, as a tool that can be used for bad, depending on who's looking at it and what it's for. Thoughts on AI and machine learning?
It's definitely a focus of the team at the CFPB going forward. And the real challenge that we see for the industry is that oftentimes the folks who are using an AI model or machine-based learning, that they don't really know what inputs are going into the decision. That they've purchased a product or developed a proprietary algorithm that may be predictive of the credit model and the participant who they want to make a decision on, but they haven't really thought through the fair lending implications of that. And the Bureau is viewing that very suspectly, and we expect that those models are going to see a lot more attention.
Yeah, we certainly saw the attention being placed on it even during the Kraninger era in 2020 with the blog post about adverse action and the use of AI and machine learning. Seeing it also manifest itself again now in recent statements by Rohit Chopra and others. So there's no shortage of attention on this topic. And certainly the risk to an organization is that it's not focused on AI and machine learning, and really from a compliance standpoint, because we have a lot of folks on the webinar today that are in compliance roles, being able to explain what it does, what it doesn't do, and reconciling that with the consumer financial laws, as well as also probably the public relations and media that the company might be using to promote the use of AI and machine learning for any number of purposes. So as Patrice Fricklin herself said, AI and machine learning, those algorithms could be used and can be compatible with ECOA and Reg B, but they're also potentially risky depending on how they're being used, and ultimately in an investigation or enforcement setting, how they can be presented in a way that enforcement attorneys and others can understand them.
Yeah, and one thing I'd add, I think Alan touched on this. Often these algorithms, you hear the term black box, meaning there's some inputs, there's numbers that are crunched, and there's some kind of an output. Often these are developed and they can be quite effective because they do reflect biases, right? Which is really, I think, what Patrice is getting at in her statement. If you're creating lookalike profiles or something like that, as opposed to measuring someone's creditworthiness, that's a lot different than doing a cash flow analysis through an algorithm or something like that, where you really are judging someone's ability to repay, but not using FICO or traditional metrics. The problem with some of these alternative systems is they're creative, they're effective, they get good returns, but the developers don't they don't understand in some cases that inputs they're using can be proxies for protected class status. The outcomes can become skewed. And when you're a lender and you're using one of these tools, really the only way you have to analyze it is looking at your loan data and going back and figuring out that you've got disparate impact, and then trying to craft your defense, which can be difficult if you have technology that you don't understand either, which tends to be something that's manifesting itself over and over again, particularly in the fintech world. And it does make fair lending analyses difficult because, traditionally there's a regression analysis where you know what the inputs are, you know what the credit decisioning policies are and so on, and you can test against it. And you can do manual file reviews and verify that your outcomes are correct and not discriminatory. It's hard to do when you've got a sophisticated algorithm that is, quote, black box.
Sure is. And a lot of our work, even recently in the non-public confidential investigations, is helping the enforcement staff understand what they do and what they don't do, and working with our clients to explain it in a way that demonstrates the compliance with the law that's built into these programs. So switching gears, new focus on criminal misuses of cryptocurrency and regulation of virtual currency. Certainly no shortage of government agencies active in this area, with perhaps no clear mandate on any one to take the lead. Perhaps that'll be seen in the next several months. But in the meantime, Andrew, there's now a national cryptocurrency enforcement team, not all that different than the sort of teams that Mike used to run when he was at DOJ. What's this all about?
Yeah, I mean, I'll turn it over, and Mike in just a second to talk about what's happening at DOJ. But Jonathan, I think you're absolutely right. I mean, cryptocurrency is something that's new. It's been around now for a number of years, but we're really seeing the interest in it coming to a head right now from a regulatory perspective in DC, as well as in our day-to-day business counseling. It doesn't hurt that Bitcoin is kind of trading at an all-time high now and drawing a lot of interest. But certainly the different agencies in Washington, D.C. at least, are really starting to focus in on cryptocurrency to understand what it is, how can they regulate it, and where does it fit in. And so we'll talk about some of those developments. And Mike, why don't you kick it off by talking about what DOJ is doing and how they're thinking about it?
Yeah, thanks. Well, this kind of makes me laugh a little bit because back in 2011, 2012, when I was executive director of the task force, there's this thing, Bitcoin was around. And I remember just talking to folks at FinCEN and others, I think CFPB too, just saying, what is this about? I don't understand. What is a blockchain? I don't understand how it works. I feel like we as a government really need to get a handle on this. I feel like this is going to be around, but let's try to figure out what this is. And just never got around to it before I left DOJ. And, sure enough, here we are 10 years later. And they've been doing work in this area. But now, with this formation of this NCET, National Cryptocurrency Enforcement Team, it's really taking it to a different level. Probably something I should have done back 10 years ago. But it's an effort being run out of the Department of Justice. It's being led by the head of the criminal division, a guy named Kenneth Polite. He's called the Assistant Attorney General for the Criminal Division. And it's going to consist of various prosecutors throughout, enforcement prosecuting teams. So we're talking about MLARs, the Money Laundering Asset Recovery Section, CSIPs, which is Computer Crime Section. They're going to be recruiting AUSAs from around the country. And they're looking for a leader. I just checked. I don't think they've gotten an actual leader of this team yet. I'm sure they're getting lots of applications and are interviewing people, but it's going to be an operational enforcement team, and they're going to be looking at crime involving crypto with a focus on virtual currency exchanges and others involved in the industry. One thing I want to point out here is that, look, like all other task forces, and, like when I led all these other ones we're talking about, they're going to be coming up with strategic priorities. They're going to coordinate. They're going to try to make cases. They're going to do all this and that. An important thing is, I think worth mentioning, is that they want to reach out to the industry. They want to cooperate. They want to build relationships with the private industry. And so if you are involved in this industry and I would encourage somebody in this field to be proactive, to reach out and try to build a cooperative relationship with them rather than sit back and wait for a hammer to fall. I think you could reach out, talk to them, talk about what you do, how to help them identify fraud. And if they come to you, I think that you ought to be receptive as well. I wouldn't recommend doing it on your own. I think you should have outside counsel with you, whoever you choose, because they're better able, I think, to understand the nuances of DOJ and can look for any landmines. But I do think it would help anybody in this industry in the long run to take DOJ up on that offer to be have a partnership with them.
Yeah. But I mean, it's not just DOJ that has been focused here, and obviously they are ramping up. But just to flag where we've already seen other agencies heavily focused on cryptocurrency. A lot of cryptocurrency exchanges are going to be viewed as money transmitters. So you've got FinCEN, the AML regulator, and state money transmission licensing authorities looking very closely at their activities from an anti-money laundering and money transmission perspective. On the kind of more the investment side, the Commodity Futures Trading Commission, the Security and Exchange Commission have all noted their jurisdiction over cryptocurrency under certain scenarios and have been bringing enforcement actions and working there. And even the CFPB and the FTC have been looking at cryptocurrency for a number of years. The FTC has been noting a lot of consumers reporting losses and investment scams. The CFPB has been receiving a lot of complaints about cryptocurrency. Even CFPB advocates like Elizabeth Warren have made public statements kind of pushing the CFPB to get more involved in cryptocurrency. And that kind of takes us to, where is the CFPB right now? Well, most recently, Director Chopra issued a statement on stablecoins. Stablecoin is really a type of digital asset or cryptocurrency where the value is pegged to more fiat assets in order to maintain more consistent valuation. And there's a president's working group that came out with a report on stablecoins, which we'll talk about in a minute. The CFPB did not participate in that, but notably, Director Chopra made a statement anyway on the report and in stablecoins more generally, saying that that is something the CFPB is interested in. They want to understand how cryptocurrency and stablecoins are going to be used in connection, most likely with other more traditional kind of financial services, and understanding how a lot of these big tech companies that we've noted may be looking to use stablecoins as part of their products and services. So in terms of just very briefly on the stablecoins report that was prepared by the president's working group, the upshot there really, to do it quickly, is that they noted a number of risks in stablecoins, particularly if they're being used as part of payment systems. And the recommendation was essentially that issuers of stablecoins that are used for payments purposes should be really regulated like their depository institutions, like banks, essentially. So those are the types of recommendations that are being made right now to Congress and within other, for other agencies within the executive branch to look at.
Thanks, Andrew. And, also the CFPB had made headlines just a couple of weeks ago and sending out information requests to 6 big tech companies about their payment systems. This big tech information request netted a lot of questions from clients, a lot of press, all around. First off, does the CFPB even have the authority to do this? And then secondly, what's this really all about? So in brief, Andy, do they have the authority to send out information requests?
Yeah, they do. And it's an interesting area because it's their market monitoring authority that's cited. And typically they have done this in the past. In fact, I did some work early on in my time in Venable when the CFPB sent information requests to the largest service providers for community banks. So they could basically get information about overdraft protection policies used by community banks that they didn't have authority to supervise and ask for information from. So they can use this authority. They have. And the interesting thing is there's not a direct mechanism to challenge it. It's basically just they have a broad authority. I think, Rohit's view is that it's almost limitless. If you look at some of those specific information requests, it's hard to tell what they have to do with market monitoring when they're asking for things like organizational charts and specific data about transactions and so on, but they're doing that. It will be interesting to see how these requests are challenged, because again, there isn't really a dispute mechanism within the statute. It's not viewed as a CID or something adversarial, but I think it is very much being viewed as a fishing expedition that it's not clear to stakeholders. And it at this point, I'm not sure it's entirely clear to the Bureau what they intend to do with this information other than study it and learn. And, the other thing, Jonathan, is, these are not traditional financial institutions that they're asking for this information from. In most cases, they're more media platforms, and, there's a specific tie-in to their payment systems for that reason. But, it is an interesting path to watch. It shows that the CFPB wants to get in and learn more about what sort of authorities they have over these, quote, big tech, big data companies. And, I think what the fallout will ultimately be is unknown at this point.
And certainly there's the potential that other markets could be targeted as well. Interestingly here, these payment systems were not subject to supervision and regular examination by the CFPB. Possibly some maybe in bank partnership models as service providers, but ultimately not an area heretofore that had been a major focus by the Bureau. And there are others too that for any number of reasons have not come under supervision and therefore examination on a recurring basis. And as folks in compliance know, the ongoing ability of the Bureau or any regulator to do an exam of an organization and test compliance does change the nature of the organization and the regulator's knowledge of the organization and the marketplace. So for some, something like this could be sort of the first step to the Bureau gaining that knowledge, as well as also for an organization needing to react to this type of a request. Now, another takeaway here is that the CFPB is going big. Rohit Chopra has already said he wants to look at national players, systemic issues in the marketplace and risks. So the question is sort of what does that mean and what sectors might be next? CFPB has broad authority and a wide breadth of jurisdiction, although in some cases they, in court litigation and enforcement matters, they may be bitten off more than they can chew with respect to who is a covered person, as well as also in some of their interpretations of the law. Debt collection, credit reporting, all areas that have been in focus, but certainly could become more in play, and issues related to substantial assistance and service providers. There's also pending litigation right now about vicarious liability for service providers, essentially the acts and practices that happen outside of the scope of the business relationship between a consumer financial services provider and their advertiser, and in the lead generation space. So no shortage of issues. Now, Alex, one of the things though that is a perennial is UDAP authority and abusive. The CFPB rescinded under the acting director David Uwejo, rescinded the guidance that was put out by the Kraninger administration on abusive, which essentially was in effect for the last several years. But now it's again sort of open season on what is a UDAP. Thoughts on that?
So when the abusive prong was first introduced into the statute 11, 12 years ago now, there was a uproar about what that meant. It was not something that had previously been used. For example, in the FTC Act, it's not a prong, just deception and unfairness. And the question was, well, is it going to be one of those things where it's not defined? Gives the CFPB the ability to kind of back into violations just by identifying practices that they don't like and then saying that they are somehow abusive. That kind of didn't really happen. Obviously we saw some cases where abusiveness was invoked, but it was not kind of overused, or we didn't see overreach with it. The the memo that came out under, the Trump administration was designed to provide some certainty and parameters around how it would be used. I think the rescission just indicates that, and I'm stealing this from Len, that, having the uncertainty can, serve as a deterrent without having to do much, just leaving it out there and open. I think abusiveness also very much dovetails to some of the themes we were discussing earlier with fair lending. It's all about taking advantage of folks that either trust or rely on you, or that cannot otherwise see the potential issue, problem or lack of benefit to themselves. And so I think we potentially will see more use of abusiveness, but again, it remains to be seen.
Yeah, and very important for compliance management programs and product review and ongoing monitoring of organizations' practices, that the abusive concept is taken into account, given the fact that the CFPB has such broad leeway, and it clearly has shown a proclivity to use oftentimes abusive, probably from a legal sense and from our legal precedent, is a lot like unfair and deceptive in the case of the way they've been using abusive. But Alex, to your point, they might use it for all of the above, right?
Right.
So now let's get some insights from our panelists on defending investigations, observations from the front lines, and preparing for litigation. The reality is that anytime you have an investigation, it has to be sized up. There's a lot of blocking and tackling that takes place. We know that investigations, though, happen for a variety of reasons, including some of the pushing of the envelope that we've just described in the last several minutes on a variety of different topics. But there's also sort of individual ways that investigations can be launched and based on, for instance, the parallel investigations with the Department of Justice or state AGs or multi-states. Consumer complaints can put somebody at the top of the list, or obviously market size, large players in an industry, which is something that Roy Chopra's already identified as being one of his rationales for prioritization. Now, Alex, when investigations are launched, there's a flurry of energy and activity at the recipient of a civil investigative demand. Typically, that involves discussions with outside counsel, getting the facts together and understanding what the strategy is going to be. There's a lot of blocking and tackling that takes place, but there's a lot more that needs to happen when a CID comes over the transom and an organization gets that knock on the door, proverbially. What do you usually include in scope when you're sizing up a CID and working with clients?
There's not a one-size-fits-all approach. I think the most important thing is to get as early as possible a sense of the reality of what is happening at the organization. I think the instinct always is to just be very reactive and push back on scope and to focus on the initial burdens involved in responding to a CID. And while those are important, and certainly the deadlines that are built into CIDs, are very important, and failing to meet them can result in waiver of important rights and other consequences. I think what, though, is more important and more pressing in terms of needing brain power from the right people at your organization is understanding what's the end goal of this. Clearly, everyone wants an investigation closed. Everyone wants to get that letter, but that's not always realistic. And understanding what the reality is, if there are problems, the scope of those problems, and what could be an acceptable outcome, and even a spectrum of outcomes from what you really want versus what you can accept and everything in between. And then you back into your strategy from that. In some cases, there's a problem and you take a very different approach with staff even in dealing with the CID, than if you really think that it's a fishing expedition based on a policy agenda and not a specific, violation. And so all of those to go into account when deciding how you're going to react to the CID, the specific requests, and also the tone that you set with staff coming out of the gate, because you will need to do a meet and confer within 10 days and set that tone up front.
Alan, preparing as if there could be litigation or at least robust settlement discussion comes into play during this early time period. How about during the course of an investigation when you're essentially, serving up facts, hopefully putting attention on where compliance has been effective? What can organizations do and anticipate needing to do when they're under investigation during that fact gathering stage and leading up to what potentially could be essentially the CFPB's decision whether to sue or settle, and maybe pushing the boundaries of the law?
Well, because we've done that early case assessment that Alex just talked about, and we have our story, we want to tell it early and often. And so throughout the time where we're feeding information to the agency, we're trying to tell our view of the facts, our view of the data, our view of the legal theories that we think the Bureau is crafting. But ultimately, all of that comes to head with the Bureau's Notice of Opportunity to Respond and Advise, or NORA, as I'm sure many folks on the call are familiar with. And by the time you get to that point, your response is often helpful at the margins and can narrow the scope of relief, narrow the legal issues that the Bureau is considering. But at that point, they have typically built in the result that they want and have decided whether they're going to move forward with a public action or not. So really having that early case assessment and frequent interaction with the staff is critical.
Now, that being said, the CFPB, where they have litigated, is actually not invincible. Now, there has been over 300 public enforcement actions, and only a handful have actually gone to litigation. Oftentimes more, they've been settled, and maybe even settled in litigation. The court record has not always been terrific when they do go to court. Now, maybe that's a function of those cases that have gone the distance. But Andy, one issue that you're very familiar with from the mortgage space, but I think that we're likely to see again, is this question of fair notice, reinterpreting the law after many government agencies have actually interpreted it before. Any thoughts on that?
Yeah, sure. So, I think, one of the things we saw when Cordray was in charge was, and really this is a consequence of the CFPB being formed, was that the notion that all of these other agencies have been getting it wrong for years. That's why we're in a financial crisis. We're not going to heed, guidance that they issued or anything else that they had said along the lines. And, the PHH case, which Jonathan is referencing, a lot of the issues stemmed from that. There was a HUD opinion that blessed a specific practice. The CFPB more or less rescinded it through an enforcement action. It did get litigated and the CFPB lost. There were other issues with that case too, including the statute of limitations. But, effectively the CFPB was walked back from rewriting the law through enforcement to the extent that there was, that there was an actual rulemaking or something that should get administrative deference. I will caution that's different than unofficial guidance or enforcement practices or anything like that, which the CFPB can change with new leadership. It doesn't really have to give notice. They could not enforce in an area when Kraninger is in charge and then absolutely go gangbusters in it when Rohit's in charge. That's just a consequence of change in leadership. But there is some level of deference to, at least to administrative guidance that's been published.
Len, you've litigated against the Bureau. Any takes on their weaknesses and vulnerability, particularly with respect to covered persons and service providers?
The Bureau takes a very aggressive position, and I think that will only continue under Chopra. I think sometimes they litigate based on what they think the law should be as opposed to what the law is, and some judges chafe at that. And I think the Bureau, from the top to bottom, has some very strong views about the way companies should behave. Some of that I don't think is well steeped in reality. And I think, again, sometimes judges are not as outraged by conduct as the CFPB staff might be. So that has implications in court. I think also, I suspect they've gotten better about this, that the lawyers there sometimes had a difficulty understanding the difference between an investigation where they are judge, jury, and executioner, and being in court where you've got a judge, confirmed by the Senate, whose job is to call balls and strikes and give both sides, a fair and impartial hearing, and both sides have to play by the same set of rules, the federal rules of civil procedure, the federal rules of evidence. And at times they've had a hard time, I think, making that switch from being an investigative body to a litigating body. And those difficulties have had hardships. I think one of the challenges that Chair Chopra is going to have is he's been a big proponent of deterrence, which means, naming individuals and getting financial penalties that go beyond sort of zeroing somebody out from the conduct, but putting them in a worse position. And he's also got some big targets. And you put those things together, and that can lead to a lot of litigation. And a lot of litigation means you bring fewer cases. And that's going to be a balancing act that his administration is going to have to sort out. But if you want the death penalty for everybody, and you're going after a lot of big companies, it seems to me you're going to get a lot of litigation. And that means you might not be able to bring as many cases, but we'll see.
Yeah, certainly time will tell, but one takeaway here certainly is that compliance is paramount. Good facts hopefully will lead to a good result in an investigation. And in situations where the government may be pushing the boundaries, it's important to hold their feet to the fire. Congress or the state legislatures have written a law in one way, and if the normative means for compliance in the black letter law requires one thing, the desires of a government agency sometimes, rather than to litigate, maybe hopefully to write rules and provide guidance to the industry as opposed to push people into court. But with that, for today, I'd like to thank my panelists, Andy, Andrew, Michael, Alan, Len, Alex, and our team here at Venable for supporting the webinar. For those that have been attending and are wanting CLE credit, today's code will be Compliance 2021. That's Compliance 2021. I want to thank everybody for attending today. For more information about consumer financial services, legal and regulatory topics from Venable attorneys, including our panelists, please check out venable.com/CFS/publications. If you're watching on YouTube, click subscribe and ring the bell for notifications, and watch your inboxes for announcements from us, as well as also this slide deck and the download for the viewable version of this webinar later this week. On behalf of my panelists and everybody at Venable, I'd like to thank you for attending today.